Hey everybody, how's it going? It's the Daily Shooter, and today I want to give you guys a quick update on Duncan v. Becerra, which is California's magazine ban case. You guys probably know it because of Freedom Week. Now, today was a very big day. We were all waiting to see what Javier Becerra would do, because today is the last day that the Attorney General of the state of California had to file for an appeal in this case. This case is already been decided on twice. We had Judge Roger T. Benitez say that it was unconstitutional, but then it was stayed, and so it went up to a 3-judge panel for the Ninth Circuit Court of Appeals. 2 of the 3 judges said it was unconstitutional, and so again, you know, the appeals process could continue, so the stay was in place and nobody could buy magazines. But we were all waiting for today to see what Becerra would do, because typically he files for an appeal really fast. This time it's been 2 weeks as of today, and we still hadn't heard anything back about it. But unfortunately, I just checked, and it looks like this a-hole filed a last-minute appeal for an en banc hearing. That means that 1 judge heard it, now 3 judges heard it, and now he wants a full panel from the Ninth Circuit to hear it. That means that basically we got to wait now for it to be judged a third time. A third time now. So I wasn't sure what he was going to do. I was kind of falling on the side of he's not going to file for the appeal, but apparently I was wrong. He waited to the very last minute in a-hole fashion and decided to file for the appeal. So I will put a link to the appeal down below if you'd like to read it for yourself, but I'll read the introduction, at least the very beginning of the appeal, so you guys know what was said here. So basically this is just filed, and it's on page 6 of 107. Introduction of Rule 35 statement. California respectfully petitions for rehearing en banc of the panel's decision, which invalidates a state law restricting large capacity magazines that can hold more than 10 rounds of ammunition, LCMs, standard capacity. We all know what standard capacity is. California voters adopted the current LCM law in response to a spat of mass shootings in the state and across the nation, and in light of evidence establishing the severe role inflicted by these things involving LCMs. A divided panel of this court, however, held that this law is among the policy choices that the Second Amendment takes off the table. He cites D.C. versus Heller. The panel's decision squarely conflicts with the court's decision in Fayok v. Sunnyvale, which is interesting because if you go back and you watch the arguments that were used, they used Fayok versus Sunnyvale when they argued their case to the 3-judge panel. The 3-judge panel had already heard about that case and basically said that that case was irrelevant to the current case that was there. So again, he's still saying that they're talking about that particular case in order to give merit to their argument. Which affirmed the denial of a preliminary injunction with respect to material identical LCM restriction on comparable record. Whereas Fayok applied in intermediate scrutiny after concluding that the challenged law did not severely burden the core Second Amendment right. The panel here applied strict scrutiny after concluding that California's LCM laws imposed a substantial burden to the core right to defend hearth and home. Opinion 31. The panel then reasoned that in the alternative, that California's LCMs would fail intermediate scrutiny. The portion of the panel's decision creates further inter-circuit conflictions by breaking from the established standard governing intermediate scrutiny and by rejecting Fayok's application of that standard to a comparable law. So basically what they're saying here, if I can understand this correctly, is that they're saying that there is multiple thought processes or multiple decisions that have been made within the court over things that are very similar to this, and some people have ruled one way and some people have ruled another way. And so because there is indecision within the courts based off of these 2 cases, that they want clarification from a full judge panel. And so again, they're saying there was indecision in this, and indecision, not indecision, but there was one decision and another decision which had conflict with each other, and so they're using that now to say that that's why they're going to be filing for an appeal, so that a full judge panel could then make a final decision looking at both of these cases and their constitutionality. So here we go. Again, we continue. We're going to move on down the line with an en banc hearing in the Ninth Circuit Court of Appeal. Let's hope once again that it falls into our favor.